so that he can be able to ensure that the quality of the commodity he gets is of the right standard. So those basically are three main factors that will favor contract farming. And then, what are the main objectives of contract farming? Okay, by now you should have guessed that one of the main objectives of contract farming is to promote coordination. Okay, and in agricultural economics, they call that vertical integration. Okay, and the other reason why coordination is necessary is to be able to motivate performance and, of course, to mitigate risks. Okay, there are risks from the buyer side in terms of quality. There are risks from the producer side in terms of price. Okay, often prices are very low when the crops are in season. Okay, when there is a glut, and the prices are high when the supply is low. So to be able to shelve the producer from these fluctuations in market prices, one can be motivated to enter into contract farming. Okay, so the other benefit is that contract farming is a mechanism for governing transactions. You have at least two parties, and they are meant to transact business. You need to lay the rules that will regulate how they transact. And of course, the other benefit is, of course, it is a tool to promote access to markets, and it also ensures agreement on the allocation of value, the allocation of risks, and allocation of decision rights. It is also a mechanism to reduce uncertainty, especially to the producers, and of course, there are also a number of stakeholder benefits. Okay. Now, in this case, we have. Let me just point here. In this case, we have that contract farming ensures agreement on the allocation of value. What do we mean here by the term allocation of value? It basically relates to the distribution of the potential gains from the contracted transaction. Okay, what is in it for the buyer? What is in it for the producer? Okay, and in specifically, this has to do with the price or the price determination mechanism. If the price is not stated from the outset, then at least the contract must be able to outline the mechanism for ascertaining the price at one point. Okay, and also it has to do with the delivery conditions under which particular prices are to be paid. Okay, the prices to be paid are contingent about certain agreements, for example, the quality of the product. If the quality does not meet what is agreed upon, then the buyer may not be in a position to pay. And then in terms of allocation of risks, this relates to the uncertainty that contract partners face, as well as the potential financial impacts of these uncertainties. And of course, the mechanisms to reduce the risks. In other words, it makes clear who bears the market risk, the production risk, as well as the transport risk. There are a number of risks associated in contract farming, and the parties need to agree beforehand on how to be able to distribute those risks so that everybody mutually benefits. In terms of allocation of decision rights, this relates to the control one or the other party has over the numerous activities and decisions that together constitute the transaction. For instance, uh, especially in a production management contract, allocation of substantial decision rights over the production activities is to the contractor or to the buyer. Okay, there is vertical integration, chiefly because he would like to ensure that the quality of the product he gets is of acceptable degree. And of course, when that happens, it also lessens the liability of the producer. Okay. Now, minimizing uncertainty is the other objective in any contract farming. And in this case, the contractor will provide a guaranteed outlet, and that is the market. Okay? The contractor thereby reduces the uncertainty about the quality of the product. Okay? And that he will receive because because of vertical integration, and is able to be able to control how the commodity is produced, and then the producer, on the other hand, already has some certainty about what to expect from what it produces, because remember that the prices had been predetermined in the contract. And in terms of smallholder benefits, we have, for example, reduced production as well as market risks, and also there is improved access to inputs. Inputs are normally out of reach to many smallholder farmers, and when they come into contracts with potential buyers, these contractors or buyers can be able even to loan them some money. They buy the inputs so that the quality as well as quantity pre-agreed in the contract can be met. Okay. There is also the element of technical assistance. Normally, the buyer or the contractor will provide certain necessary technical assistance to the producer. And of course, there is also the possibility of access to credit, and finally, the farmer will benefit from stable income and poverty reduction. Okay, so these are the 5 main models of contract farming. Okay, you can have the nucleus estate type, the multi-partite type, the informal type, the intermediary type, as well as the centralized type. I'm also happen to be a small-time sugarcane farmer, and contract farming is something that we practice quite a lot, at least in the sugar belt in Kenya. So normally, most of the sugar factories, I don't know whether it's the case also in Uganda, but what happens is that the sugar factory has got a nucleus estate, but also they allow, outgrowers to supply cane to the factory. Okay, the existence of the nucleus estate is basically to guard against production risks, and sometimes the factory also uses the nucleus estate for research. Okay, and the outgrowers come into contract with the factory to supply cane. The prices may be pre-agreed, or there may be some mechanisms that are pre-agreed in order to set the prices. So that falls under the nucleus estate model. Okay, but in all these models, okay, the basis is the type of contractor, the type of the product, the intensity of vertical coordination that is necessary between the farmer and the contractor, as well as the number of key stakeholders that are involved. In the centralized model, in this case, the processor or the buyer will normally buy the produce from a large number of smallholder farmers. This is almost tending to what economists call monopsony. And this is where the buyer has control over the prices. There are quite a number of suppliers and one buyer. So there can be some sort of power disparity in the sense that the buyer can have almost exclusive control over the prices. And there are mechanisms to be able to shelve the farmers from such excess uses of power. The nucleus estate, we have described that, which is very common, at least in the sugar sector, in the East African region. And then you have the multi-party model, which is basically a joint venture between a statutory body and a private company entering into contract with the farmers. Okay? So on one side, you've got a venture between a statutory body and a private company. That could even be a government arm, together with a private company, and then they contract with the farmers. Okay? You may also have public or private providers of credit, like banks or such other financial institutions. You may also have entities providing extension services as well as inputs. All this may be part of the multi-party arrangement. And then there is the informal model, which is characterized by individual entrepreneurs or small companies contracting informally with the farmers on a seasonal basis. This is a little bit unstructured as compared to the previous two, but it is often the recourse that is taken by many farmers, especially those that produce fruits and vegetables. Okay? Crops usually require only a minimal amount of processing. These are the crops that are suitable for contracting under the informal model. And the minimal processing we are talking about here might include basic sorting, grading, as well as packaging. So the processing is not quite involved. All right? And then you have the intermediary model. And here, there are at least three parties to the contract farming arrangement. You may have a processor or a major trader, and formally coming into contract with a collector. This is a sort of a middleman who then informally contracts with the farmers. So I don't know, the aggregation model kind of falls around this. Maybe allow the feedback from the Agra representative here. Now, this model is sort of a combination of the centralized and the informal models. And in this case, the farmer does not engage directly with the buyer. And there are also advantages as well as risks that is associated with this model. The idea is for us to be able to see the models as well as the typologies. So depending on your circumstances, you can be able to choose the right arrangement of contract farming for you. Basically, you've got three types of typologies, okay? And these are defined either from the farmer's perspective or from the buyer's perspective, okay? From the farmer's perspective, we have got the market specification contract, we've got the production management contract, and as well as resource providing contract. From the buyer perspective, we can have procurement contracts, we can have partial contracts, or total contract. I'll give you notes on this so that you can be able to go through each one of these for the sake of time. Now, these are some of the challenges. Contract farming is not all bliss, okay? Whenever you have at least two parties involved in agreement, there are bound to be challenges as well as risks, because people often have different motives. And when those motives are not properly aligned, then it is possible there could be challenges as well as risks. Now, some of the challenges in contract farming, one of them is that there are the possibility of winners as well as losers at the community level, and this can lead to social tension. Contract farming can also adversely affect the production of basic crops. In other words, we will be emphasizing on cash crops at the expense of, say, food crops. And I believe we are all familiar with this. Okay? It can also lead to a more narrow local farm market. And this will expose non-contract producers to face thin markets at lower prices. Okay? And then it can also lead to a dependency relationship whereby the farmers are dependent. They are at the mercy of the buyer or the contractor. And this can result in some kind of exploitative behavior. Okay? Contract farming can also lead to gender inequalities, both in terms of quantity as well as quality. And of course, it can also lead to overexploitation of natural resources. Now, these are the main conditions influencing benefits from contract farming. The first one is a seller's market, and then there is also supporting state policies. There is also balance, power, relationship, and then there are also certain standard crops that are amenable to contract farming. And then there is also collective action in producer organizations as well as support from NGOs. Okay? If the legislative regime in a country does not explicitly support contract farming, then this can pose challenges to contract farming agreements. So in many of the countries in East Africa, I think there are certain legislative provisions in our laws that kind of define conditions for contract farming. And then in terms of power balance, in any value chain, one of the key problems is power disparity at various value chain nodes. And normally the farmers are often the disadvantaged, especially the small scale farmers, where they could be ignorant about market prices due to information asymmetry, for example, and because of that, the middlemen can take advantage of them to pay them peanuts, and when they deliver the produce to the market, they reap all the benefits. That is due to power as well as information asymmetry in the value chain. And then collective action in producer organizations, this is one way that can help leverage or rather minimize the power disparities that might be inherently existing in the value chain or in the production system. And normally, organizations that cut across countries, yeah, like the EAC or the EABC, this is one way in which you could support self-association of farmers. Yeah, so that means when they form a producer organization, they have more bargaining power to bargain with the prospective buyers as well as middlemen. If there is just one farmer that is negotiating about prices with a more powerful, more informed middleman, you can see that he is likely to be shortchanged. But when they come together, okay, they have a greater bargaining power and they can be able to influence the outcome of price negotiation. So that is one advantage of collective action in producer organizations. And the NGOs have a very important role in supporting especially producer organizations to better negotiate with the buyers. Okay? So these are some of the key conditions that would positively or negatively influence contract farming. For example, by their absence. Now, I'm trying to go very fast. As I said, I'll avail all these notes to all of us. They are written in very simple language and you can be able to understand. But the important thing is that we're just trying to fit within the span of time that we are being allocated. Now, on contract formation and negotiation. Okay? Normally, contract formation involves a series of steps. As you can see there on the screen, there is in the beginning, you've got negotiations and preliminary exchange of information, and then there is delivery of an offer and the acceptance of it or rejection of it, and then there is contract preparation based on what has been agreed upon and signing the contract. Okay, basically those are the stages, and there are certain pre-contractual documents that might be useful in order to inform both parties on how to negotiate for the contract. And this includes there must be a list of producers that are involved in the same production. Okay? The farmer coming into a contract with a buyer would be interested in the other farmers who are already contracted to the same buyer. Okay? And then there is the need for a list of the former producers that the buyer might have dealt with. That can give you some history as to how this buyer behaved. Okay? Whether he can be able to sustain contracts or perhaps there's some mischief. And then there is also the information about the contractor itself. You'd wish to know the solvency status of that particular contractor and the rest of the attributes that will make you to be able to believe in him or her as you come into contract with it. And then there are also rights and obligations of the producer as well as the contractor. It is very necessary that the parties are aware of their rights and obligations under the contract. And then one should also be able to know the investments needed for production and of course the cost of production. There is also the need to know the expected price as well as the potential revenues from the contract. And then one also needs to know the criteria for acceptance of the goods. And then the mode of inspection as well as quality monitoring, production monitoring, the mode of harvesting, the mode of transport, the mode of delivery, the mode of storage, as well as the environmental liability. All these are very, very important preliminary knowledge that both parties need to be abreast of before they can meaningfully engage in a contract negotiation. Okay? And then once that happens, you need, on top of all that, either party needs to have complete disclosure. Okay? All the information that they know pertaining to the contract that may not be very obvious to the other party needs to be put on the table, and basically to avoid both asymmetry of information. And the parties to the contract must be competent. There is something called legal competency, which I'll ask the lawyer at the back there to explain for us. There is need for the parties coming into the contract to have some degree of legal competency in order to be able to come into the contract. And then no party should have undue advantage or leverage over the negotiation term. The negotiation should be level. The playing field should be level without any of the parties having undue advantage over there. And then We'll try to consider each of the stages in a little bit more detail so that you can at least appreciate what they entail. So the first stage we said was negotiation. Okay, and this is basically how the consumer and business decisions will interact to determine the allocation of resources between goods and services. Okay? And basically, negotiations will seek to obtain a common agreement that interests all the parties to an agreement. Like we said, all this is written in very simple, explanatory language. There's no legal jargon, and you'll be able to understand. And negotiation is also a kind of coordination mechanism in contract farming. And of course, it leads to mutual specification of the terms pertaining to a contract. And each negotiating party needs to set a series of realistic goals before entering the negotiation process. We'll look at the various goals in terms of price negotiation that each of the parties need at least to be clear of in the mind. Okay? Now, buyer requirements and agricultural policies should often be stated beforehand. I mean, agricultural prices. They should be stated beforehand. And then, when an agreement from both the buyer and seller is achieved, each of them will thereby receive benefits or payoff. And that is basically the objective of getting into a contract farm. Mutual benefit for the parties involved. Now, the preparation phase involves all that is listed there. You have setting the goal and then sizing each other. Of course, you need to know who you are negotiating with, and that you need to determine beforehand the best alternative to a negotiated agreement. And there should also be a determination of what is called a reserve price. This means the minimum value influencing the negotiation outcome, whether there is an agreement or disagreement. Okay? The minimum value that will influence the negotiation outcome, whether the outcome is agreeable or not. And then there is also what is called aspiration price. This is usually a proposed value and the aspiration price. No, the buyer has the price aspiring to, as well as the producer. Okay, and then if the proposed an agreement can still be reached provided the proposed value is still higher than the reserve price. Provided the proposed value is still higher than the reserve price. The proposed price in this case relates to the offer that is made by either party. This is a negotiation, it is a bargain, and each party will be proposing what they feel is good in their best interest. So this is just a diagram illustrating what we refer to as the distributive aspects of negotiation. There is a continuum. On one side, you have the buyer aspiration price, and then the other extreme, you've got the seller aspiration price. And you can see the yellow shaded area is known as what? The ZOPA. In other words, the zone of possible agreement. Okay, this refers to the acceptable price ranges that will result in an agreement within the negotiation process. So basically, if you are in that range, there is a possibility of some sort of a mutual agreement between the buyer as well as the seller. You can see that the distributive aspects of a negotiation overlap between the two negotiators. Okay, and an offer of the agreement, the prospective terms, usually from the buyer, should be made normally in writing. It helps for the offers to be made in writing. And in some jurisdictions, this could even be a legislative requirement. Okay? And under general contract laws, which we shall look at later, there is a mere acceptance of an offer by the offeree could be sufficient to form a contract. Okay? This is could be a specification under the general contract laws. And we shall look at this when we consider the legislative framework for contract farming. Okay? So I don't know if you can be able to see this, but it's just an iterative depicting the various decisions you have to make so that finally you end up having a mutually agreeable condition to be able to seal a contract. Yeah, but of course you will get it in the handout, so you can be able to appreciate it further there. Now, so that leads us to, I don't know if I can stop, maybe so that we can have some sort of a feedback, or I can just rant on until I finish, and then at the end of it, we could come back and then maybe have some sort of a feedback of the audience. What do we do? I continue. Very good. And then we can have all the time at the end to interact. The idea is basically to give you an overview of what this entails. Of course, this is a specialized field, and obviously, we couldn't have covered everything within the time that we have. So, if you can go home at least with some sense of what contract farming is, then at least I would be happy. So, the legal and regulatory structures of contract farming. Normally, these are governed by a national legal framework. But of course, we are talking about a region. So there could also be a regional, some sort of legal framework. Okay? And this pertains whether or not a country may have adopted any legislation containing specific rules for contract farming. Okay? And there are various laws and regulations that may be applicable to contract farming. The one that we have already mentioned is the general contract laws, or you may have specific agricultural laws, or there may be certain supply chain legislations as well as commodity specific legislation. Okay? I remember in the days when coffee was the black gold in Kenya, there was specific legislation around coffee to the extent that a farmer would not be able to uproot his own coffee unless he has expressed consent from the coffee board of Kenya. Okay? So it can be that detailed depending on the specific policy targets of the country. But these laws and regulations may further rely on what are known as default rules, or these are applicable whenever the agreement is unclear or is incomplete or silent on a particular issue in contract farming, which is related to the legislation. Mandatory rules, on the other hand, are those that may not be varied nor excluded by the negotiating parties. Okay? And often these rules limit the freedom of negotiation by, for example, obliging the parties to either include or not include certain provisions in the contract. Okay? Now, so this is just an example of the hierarchy of the legislative framework, at least in Kenya. Okay? The source of all laws is of course in the Constitution, which in the case of Kenya is the 2010. This is the latest version of the Constitution in Kenya. And then under that, there is the Law of Contract Act. This is an act of parliament, especially Cap 23. And you can see here, I'm giving the example that was revised in 2021, and this is on law of contract, as it were. And then further down, you can have specific commodity legislation. And you can see here, legislative supplement number 58 of 2020. And this is basically on sugar regulation. Okay, so this is where we have contractual, with the legal provisions for contracts in the sugar sector. And we shall look at that in our practical. And so that just gives you how the legislative framework is cascaded, at least within a country. Okay. Then when we move on to global best practices, and these are basically a set of guiding principles, and the aim is to be able to stem the possible imbalance in market power, opportunistic behavior, or other unfair practices. Okay? And of course, the other aim is to promote responsible contract farming operations. And these guidelines also serve as a guidance for and buyers engaged in contractual relationships. And they also promote good business practices, and they will help to maintain an atmosphere of trust and respect that is essential if contract farming is to prove effective. So here is an outline of the main principles that are involved here. You have, of course, the first principle is that there must be a common purpose. And then there should be strict adherence to a legal framework. There should also be clear documentation in the contract. And then there is also the need for readability of contract. The contract, especially the smallholder farmers in many of our countries, perhaps have only, not very high level of education. And if the contract has got a lot of legal jargons, then of course they will not be able to understand. It is in the interest of both parties to ensure that either party understands the content of the contract. And then in some cases, you need even to translate that into mother tongue so that the party can be able to also be due attention. But also be due attention as well of the contractual obligations as it may be necessary. And we've also talked about disclosure in order to avoid asymmetry of information. For example, there should also be transparency in the price determination. Okay? In other words, both parties must be reasonably aware of the prevailing market prices so that they can negotiate towards that price. In cases whereby, for example, the producers may not be very much aware of the prices, or the price setting mechanism is obscure, then there is the danger that the contract may fail altogether. And then there is also transparency and fairness in clauses relating to quality. Okay? The buyer demands that the produce be of some quality. This needs to be transparent. They also need to be fair, at least from the producer's side. He has to be able to have the means to produce the commodity that will deliver on the acceptable quality. And provided the contract outlines it, the producer will also be will also have to be able to provide all the necessary inputs as well as technical advice that will ensure that the required quality finally is obtained. And then there is also transparency and fairness in the clauses related to input supply as well as use. This is also very important. Normally, the resulting quality or and even quantity of the produce depends on the level of input used and the types of inputs that are used. Recently, we have a fertilizer subsidy program in Kenya where the government was providing subsidized fertilizer to small-scale farmers. And I don't know, there are some people who somehow get in the middle there and they end up selling fake products to the farmers. So you apply a lot of fertilizers, but the maize doesn't do very well. So such risks are also possible, and sure there should be clear specification of the input supply to be used by the farm. And then there is also fairness in risks sharing, particularly in terms of force majeure and other contractual flexibility. These are, I would say loosely, that unforeseen circumstances that may occur in the future and jeopardize the contract. And in this case, either the buyer and the producer really don't have control over such cases. So there has to be provisions on how to manage the contract when. And then there is also prevention of unfair practices in buyer-farmer relations. This has to do with power disparity, and there needs to be specific clauses in the agreement to take care of such misdemeanor of either party. And then there is also honoring contractual terms. Okay? Otherwise, there will be no need to come into a contract in the first place if either parties are not prepared to honor every provision in the contract. And then, of course, open dialogue often helps. Normally, because of misunderstanding, you can have a contract being jeopardized. But if the parties are engaged in open dialogue, then it can be able to stand some likely conflicts in the contract. And of course, there should be clear mechanism to settle the disputes. Now, in the next slide, we outline just very briefly some sort of mechanisms for dispute resolution. Normally, disputes will arise and the parties may not be able to solve these disputes on their own. So there is need for intervention of a third party. Okay? Especially in agricultural production contracts, the following areas may be prone to controversy. The first one is either the quality and quantity of the delivered goods or the final product. The second one is producers' compliance with agreed production methods. The third one is occurrence of relevant events for discharging the parties from their obligation. And then application of the pricing mechanism as well as grounds for terminating the contract. These are some of the key areas that often lead to conflict in a contract. However, effective and accessible mechanisms for dispute resolution will ensure that there is contractual justice and that there would be contractual compliance. So these are some of the key steps in dispute resolution. Okay, you can have what is called mediation, you can have arbitration, and then judicial proceedings. The first two are non-judicial, and they are often preferred. And if they fail, then one would then be forced to resort to judicial proceedings. Okay? The parties can agree to a first phase of negotiation, even subsequent mediation, and then if they do not agree, then as a last resort, they can then lead to judicial proceedings in the courts of the land. Now, basically the steps that are involved in dispute, resolution involves initially amicable procedures, arbitration, and then judicial procedures in that sort of an order. Okay? I think it is in the interest of both parties to try as much as possible to explore the non-judicial procedures, and only if there is irreparable damage should they now resort to the courts to be able to settle their disputes. Okay? At any rate, the application of these dispute resolution mechanisms depend on these three factors. Okay? One is the nature of the dispute, the time factor, as well as the necessity for interim relief. Okay? In certain legal systems, especially when there are public or governmental parties being involved, the dispute resolution would fall under mandatory jurisdiction of administration. Dispute resolution would fall under mandatory jurisdiction of administrative court. So in this case, the parties would have no alternative but to resort to judicial sort of procedures to resolve the dispute. And then there could be the necessity, it is often in the interest of both parties that any arising disputes are resolved quickly, and expeditious dispute resolution would be necessary in order to avoid economic losses, in order to restore parties' trust, and also to allow their relationship to continue. This is in the interest of both parties. And there would be, especially in certain specific circumstances, the need for temporary relief, especially if the dispute resolution process is likely to be protracted. Okay? And this is to prevent irreparable harm to a right, to prevent destruction of goods or evidence, or to ensure enforcement of a future judgment. Now, the government is very important in contract farm, and these six are the key roles that the government can perform to facilitate the contract farming. And I guess even at the East African community level, especially in cross-border sort of contracts, they can assume similar roles to what happens at country level. So the first one is improving the producer's technical and contractual capacity. And we, sitting in this workshop, are squarely undertaking that first role for a transborder organization, African community, or the East African Business Council. This is in fact what you are doing here, okay? To be able to improve producers' technical as well as contractual capacity, so that they can be able to negotiate for contracts from a knowledge perspective. And and then to promote efficiencies in contract farming, and then also to encourage and support self-association of smallholder farmers. We say this is often necessary in order to be able to improve the bargaining power of producers. Okay? When they act singly, it, the bargaining power is not as effective as if they act in a group. So this is the basis of the cooperative principle that I think many countries in East Africa have used to a lot of advantages to develop various, especially crop value chain. Okay? And then governments can also provide an enabling regulatory framework to support contract farming. Okay? If there are clear and specific legislation to facilitate contract farming, this can considerably help, as opposed to being in a jurisdiction where the legal framework is obscure. That leaves room for a lot of potential conflicts in a contract. And then the governments can also help in market regulation. The government can help in market regulation, especially if the laws of supply and demand cannot be able to exact, exact prices that would be amicable to either party. Governments can come in to regulate given prices. I've seen this working in Kenya, in the sugar sector, in the tea sector, and various other cash crop sectors. And then there is also the need for the government to facilitate dispute resolution. Okay? Governments or governments appointed agents. And because we said that certain conflicts, the parties may not be able to address certain conflicts on their own. And then there is need for a third neutral party to intervene to be able to bring them together again. And that is the role of the government or an appointed government authority. Okay? So, this next slide just shows you the main provisions found in most agricultural contracts. Okay? Normally, a typical contract would have a duration. Okay? Quality standards to be applied either on the input side or the product side. There should be also provision for quality control. That is, when, how, who is responsible, and who pays for all this. And then the quantity that the farmer is obliged to deliver to the buyer. That needs to be categorically stated. And there is also production practices that are required by the contractor. Remember that the resulting quality of the produce is dependent on the production practices. So this needs to be outlined beforehand as a guide to the producer so that he or she can be able to meet the contractual obligations in terms of quantity as well as quality. And then the timing of the delivery. This is important, especially if you have a factory and you need the raw materials to be able to configure your production schedules. You need to be able to know the timing of the delivery so that you don't have a lot of factory downtime as a result of non-delivery of raw material. Now, the packaging, transport, and other delivery conditions also need to be clearly stated. All this can drastically influence the quality of the produce when it arrives at the factory. Okay? The rate of deterioration of certain produce depends on how it is packaged, how it is transported, or even how it is delivered. So to be able to avert all this needs to be specifically stated in the contract. And then the price or the price determination mechanism, very important. And this is often the motivation that makes producers to come into contract farming. Okay? The assurance of a price, come what may. And of course, the sort of technical assistance that the producer would need in order to deliver on the contractual obligation. Such technical assistance can be rendered by the buyer or by a third party. It can be a government, or it can be even an NGO with specific technical know-how in that particular area. At any rate, you need to be able to specify the sort of technical assistance that would be required. Now, there is also the procedures for paying farmers, and reclaiming credit advances. Okay? Normally, the producer may not have the wherewithal to be able to produce, and often the buyer would avail credit facilities. How does he recoup that when the producer finally supplies the produce? On the other hand, how does the buyer pay the farm? In the sugar industry, which I'm more familiar with, most people in Kenya even stopped farming sugarcane altogether because you deliver your thing to the factory and it takes even 4 years before you are paid. So you ask yourself, what is the use of committing further to this contract? So people abandon sugarcane because the bank was not honoring terms that they had initially contracted. Okay? So there needs to be clear procedures for payment. And then the issue of insurance is important, especially based on the challenges. Least of them are related to climate change in agricultural systems. In some jurisdictions like Kenya, index insurance is becoming very important, and this is whereby the farmer gets insured, and then if there is crop failure, say due to a prolonged drought, then it can be able to get some sort of a compensation. So this is something that is gaining currency, I believe, in many of the East African countries. I know it is pretty well advanced, at least from index insurance point of view in Kenya. And then procedures for dispute resolution, some of which we have already mentioned about issue. And then this is FAO's agreement on contract farming, just the elements of it. There is a longer version which I will avail to you on each of these specific items. Yeah. So basically, this would be in many standard contracts. Okay. The parties involved, the purpose of the contract, the production side, the product itself, good provision, delivery and acceptance, pricing mechanism, force merger, remedies, duration, renewal, termination, dispute resolution, and of course, the signatures must be affixed at the end to ratify that the contract is binding between the two parties. And of course, there could be specific annexes that are necessary in the implementation of the contract. This is just an outline. I have another more involved, outline for each of these stages, which avail to you. Okay, so that would form the end of my very brief but extensive overview of what contract farming is all about. Thank you. So, Frank, I don't know how we proceed from here. Either we can be able to uh, respond to comments from the audience or let us break or something. I can see the CEO has a burning comment.
Yes, let me also assure you that we will share this presentation, but also there is the professor prepared notes. It's not only going to be PowerPoints, but also notes. And as part of this training, you will get the model contract. So this contract is also is drafted in a way where you can go and customize for your members or for your clients will also be provided to you as part of the training. So we are opening the room for questions, but also it's a time for you to open your mouth. You know, some of you have been very quiet. So you are very welcome. I'll see you.
Yeah, thank you very